Welcome to Wadsworth History on Film, a program presented by the Wadsworth Area Historical Society and designed to record the oral history of Wadsworth for posterity. I'm Caesar Carino, your host, and our guest today is someone that we all know, Norman Brague, who is the law director for the City of Wadsworth. Now, we had Norman on once before. However, we are having him come back so that he can give us some of the odd kinds of cases that have come before him over the 24 years that he has been the city director of law here in Wadsworth. Norman, but before we do that, how about telling us a little bit about yourself, where you were born, who your parents were, and all of that, and where you lived and where you went to school, so that those people who did not see the first program will be able to know who you are and what you do here, how you became so important in Wadsworth.
Well, I was born in Marietta, Ohio in 1946.
And what day?
October 16th.
October 16th, 1946. So you're getting beyond that 50 mark to about 54 now, aren't you? 42, 53?
52.
Not yet. Oh, you won't be 53 until October.
Right.
All right.
My parents were Clive Brague and Kate Brague, who were residents of Woodsfield, Ohio when I was born. I lived in Woodsfield, Ohio, and also in Byesville, Ohio, in southern Ohio, and I came to Wadsworth when I was 12 years old in 1959. My father died shortly after we came to Wadsworth. He died in 1962. My mother taught elementary school at Overlook School and lived the balance of her life in Wadsworth, and she died in 1982. My parents are both, of course, buried back in southern Ohio, but I plan to stay in Wadsworth the rest of my life.
And will you be buried here?
Yes.
Oh, so you're going to stay here. You're going to be a permanent resident of Wadsworth.
That's right.
Well, that won't happen for many, many years, we hope, Norman. You went to elementary school here.
No, I went to junior high school
Junior
here.
high. And tell us a little bit about your junior high school days, as you remember them.
Well, I remember junior high school because, of course, it was a new experience having more than one teacher. Before that, in elementary school, I had just been in one classroom, but in junior high school, there were several different classes, and each teacher would stay in a classroom, and then I would, as well as the other students, would walk from classroom to classroom. And I can still remember some of the teachers and some of the classes. I can remember having Pauline Bebout for English class.
I had Pauline Bebout as a substitute about 60 years ago. A very powerful woman.
And Laurel Mast for mathematics, and Mr. Johnson for science. And there were quite a few memories I have of those days. Then when I was, of course, at that time, the 9th grade was also in the junior high building, and I remember I had Mrs. Gilbert for French, I believe, in the 9th grade, and I'm sure there are others that I would remember if I thought about it a little more. Sometimes it's a little hard to remember who was exactly what year after all these years.
Your interest was history, is that correct?
Yes. Mm-hmm.
And who were your history teachers who invigorated you to become a historian?
Well, I had several. I had Tom Hampton, I remember, and Jack Schaefer taught history, and also...
Didn't his wife also teach, Barb Schaefer?
I did not have her as a teacher, but I do believe she was a teacher.
And now, apropos, at this point, I think would be some kind of a declaration of what you have done with history in addition to law. And I'll give you a little clue. County courthouses.
Well, in the early 1970s, I traveled around over Ohio in 1973, 1974, and I visited every one of the 88 counties in the state of Ohio, and I photographed all the courthouses. So I have a collection of photographs from that era of courthouses all over Ohio. A few years after that, there were a couple of books published which had collections of courthouse pictures, and I have those. So I do have the experience of having visited all 88 counties and having seen all 88 courthouses, at least from the outside.
Which one is, in your estimation, the most notable?
Well, they're notable in different kinds of ways. I think probably in a way, to me, the most notable are the half dozen or so pre-Civil War courthouses in Ohio.
Where are those?
Well, one of them is in McConnellsville, has a very beautiful
What county is that?
pre-Civil War courthouse. That's Morgan County. Highland County is another county which has a very old historic courthouse. Brown County is another county that has a pre-Civil War courthouse. So those are three that stand out as real old ones. Now there's some others that are a little bit newer, but they're still very beautiful and very interesting. The Ross County Courthouse in Chillicothe. One real interesting feature of courthouses is there are two courthouses in Ohio that were built at the same time by the same contractors and were originally designed to be identical. Now, over the years, they've been altered a little bit, but the one courthouse is in Marion, the Marion County Courthouse, and the other one is the Fayette County Courthouse in Washington Courthouse.
And they look exactly the same then, is that right?
Well, as originally built, they were exactly the same, I understand. There's been a little bit of modification with remodeling over the years, and they're a little bit different
at this
now.
point. Where does Medina stand in this?
Well, Medina, of course, has kind of an interesting situation because part of our courthouse is very, very old, but it has been very extensively remodeled and connected with a much newer building, so we have a building that's kind of a combination of a very old building and a building that was, I believe, completed around 1970.
Now, do you have any notion as to when the first Medina courthouse was constructed? That's the present old one.
I believe it was, I don't remember the exact date, I believe it was a few years before the Civil War, the oldest part
So in other words, we do have one of the pre-Civil War courthouses also.
I believe so, a little bit of it, but it's been greatly modified since then.
Norman, when you first came here, did we have a municipal court?
No.
No. What did we do for people who were malcreants or whatever we call people who disobey the law? What's the proper term?
Well, misdemeanants would be the word for people who commit.
Malcreants might be too much, right?
Misdemeanors, yeah. Well, in 1959, when I came here, at that time, Wadsworth would have still had a mayor's court. And historically, misdemeanors in Ohio in the more urban areas were heard in municipal courts, and in the more rural areas were heard in mayor's courts and by justices of the peace. But in the late 1950s, the justice of the peace courts were discontinued and replaced for the most part by what were called county courts. And the system in Medina County was that all of Medina County, except for the City of Wadsworth and Wadsworth Township, were included in the territory of the Medina Municipal Court, which of course had its location in the city of Medina. In Wadsworth, the City of Wadsworth still had a mayor's court, but Wadsworth Township had a county court, which also had concurrent jurisdiction in the city. So cases in the city could be heard either by the county court judge or by the mayor. Well, sometime in the 1960s, a decision was made to discontinue the operations of the mayor's court and to have all of those cases heard in the county court, and the city leased space in the old City Hall building to the county, and the county court, which had previously been in the basement below what is now the First Merit Bank branch downtown, moved into the City Hall building.
Give us a geographical location where the first court was in Wadsworth, the first county court.
Well, the first county court would have been at Judge Ott's home. He was the first county court
judge. And where was that located? The corner of Leatherman Road and
College
Street. in which now, in 1999, Don
Hartman
lives,
yeah.
right?
Yeah.
That would be on the northeast corner of the intersection of Leatherman Road and College Street.
Yes, sir.
Route 97.
Yes.
Okay. We have to give these geographically, but 50 years from now, they may not be here. As a matter of fact, as we speak, they're widening the road there, and they probably will take part of the property, if not the whole house. Now, they moved from Judge Ott, and tell us a little bit about Judge Ott and who he was, and his function. He was a justice of the peace, and he worked for Hall Trucking Company, did he not?
Yes, he did. At the time he was originally appointed as a justice of the peace.
Who appointed the justice of the peace, which we no longer have?
I'm not sure who did appoint him originally as justice of the peace. I don't know
What office
originally,
appoints him?
but of course he was then elected to the office. He probably was actually elected the first time, probably.
Okay.
That was an elected office. And
Bob Ott now is now dead, is he not?
yeah, no, he lives in Arizona.
Oh, he lives in Arizona. Okay.
Yeah. He was one of the last non-lawyer judges in Ohio, because a justice of the peace who was a non-lawyer was able to continue at that time as a county court judge. So he started out having the court as a justice of the peace court there at his home, and then I understand he enclosed the breezeway and had the court in that area. And then it became a county court, and the operation was moved into the city limits, into the basement of what's now the First Merit Bank branch downtown.
Okay, and give us a geographical location of that.
Well, that would be immediately south of the Huntington Bank.
Right,
downtown.
and it's about, it's the last building before the parking lot of the Huntington Bank from Broad Street.
Yes.
On the east side of the road.
Yes.
Right, okay, we have to identify those. Now, when Judge Ott was down there, he was with the county court, is that correct?
That's right.
And you were at that time the prosecutor?
No, that was before the time I
Oh.
was prosecutor. By the time I became prosecutor, the county court had moved into the City Hall building.
And who was the judge there at that time?
And it was still Judge Ott.
Still Judge Ott.
And it was located in rooms which were located on the second floor along the south side of the building. And when I started, it was a part-time operation. The court had all of its sessions in the evenings, 3 evenings a week. And Judge Ott had another job. At that time, he was working for
Firestone?
in Akron. So he was not available during the day, but he came and heard court in the evenings. And there was a clerk, Doreen Steele was the clerk of the court. And there were 2 deputy clerks, Shirley DePietro and Alice Surface, and that was the complete staff of the court. There were no bailiffs or probation officers or anybody else at that
Let's
point.
spell all these. Doreen, D-O-R-E-E-N,
Yes.
Steele, S-T-E-E-L-E.
Yes.
And Shirley DePietro, Shirley, as we spell Shirley, and DePietro, capital D-I, capital P-I-E-T-R-O.
Yes.
And then Alice Surface, Alice and S-E-R-F-A-S-S.
Yes.
Right. Alice Surface is Jim Surface's wife, and Shirley DePietro is Joe DePietro's wife, and, well, I guess we should say that he was her husband so that no one thinks we're being sexist here. And Doreen Steele's husband was George Steele.
Yes.
Correct. And they still all are living and all
Yes.
live in Wadsworth.
Yes.
At the present time.
Yes.
Then, when was the last mayor's court? And who was the last mayor to serve as the judge of the mayor's court?
Well, that was
Called
that was before my time as prosecutor. I understand it was in the late 1960s.
1960s. So the mayor's court then would take care of misdemeanors and make judgments and so forth and so on. We no longer have that.
No.
Now, as you tried to remember the establishment of the first municipal court, what is your first recollection, which I guess, well, nothing blows your mind, but what would blow anybody else's mind?
Well, one memory is about a case that we had that was a case that, strangely enough, was determined to be a case that no court had jurisdiction of. And it was a drunk driving case, and the Wadsworth Municipal Court came into existence on January 1st, 1977, and the law provided for cases that had been filed prior to that for continuing jurisdiction on those, and of course it provided for cases that were filed on January 1st, 1977 and afterward to be tried in the new court. But there really wasn't any provision made in the law for prosecuting an incident that had occurred in the territory of the new court, but in which a case had not been actually instituted before the start of the new court.
Now, explain that, Norman. You have too many instituted and too many jurisdictions there. Tell us.
Well, what happened was there was a DWI case, and it happened on December 31st, 1976.
Okay.
So it was filed in the in the Medina Municipal Court, which at that time had or it hadn't been filed. The person had been arrested, and when January 2nd came around, they filed it in the Medina Municipal Court, but the Medina Municipal Court held that it did not have jurisdiction of it and dismissed it because the Wadsworth Municipal Court had been created. Mm-hmm. Although this offense had taken place before the court was created, because the court no longer had jurisdiction of the territory when it was filed, it dismissed it. Well, then it was refiled in the Wadsworth Municipal Court, and the holding in the Wadsworth Municipal Court was that because it had not been filed in any court before the creation of the new court, and the Wadsworth Court was not in existence at the time it was allegedly committed, that it couldn't be heard in the Wadsworth Court either, so it was dismissed. So both courts dismissed it, each saying it didn't have jurisdiction.
And is that somewhat of a landmark case of sorts?
Well, it was published at the time. It's what we call a reported case, a published case, but of course it's a very, very unlikely circumstance to ever come up, and certainly will never, ever come up again in our court.
But it came up once.
Came up once, yeah.
I guess the man who got drunk on the 31st got drunk on the right day, if getting drunk on any day is right.
No, he was very lucky. It was kind of a loophole, I guess.
What are some of the other kinds of things that have happened which would be in your memory? And we'll try to prod you with some of them, but what are some of the things that you remember that were unusual as cases?
Well, cases are unusual in different kinds of ways. Of course, two cases that I'll always remember are the two cases that I argued before the Ohio Supreme Court.
Oh, really?
And
did you win both of them?
Yes, I did win both of those. Fortunately, one of them was a split opinion, but they were both actually won. The first case was a criminal case. It was the case of State versus Erlenbaugh. And it was a reckless operation case.
Would you spell Erlenbaugh for us?
E-A-R-L-E-N-B-A-U-G-H.
Was that the person's last name?
Yes.
Mm-hmm. You remember his first name?
Leo.
L-E-O.
Yes.
Leo Erlenbaugh. And where was he from?
I don't recall. He was not from this area. He was a truck driver.
Oh, truck driver. Okay. And what happened? Tell us the situations.
Okay. He was charged with reckless operation under what was then a very new wording of the reckless operation statute. And what had happened was a state highway patrol officer had stopped another truck. This was back in, I believe, 1983. Had stopped another truck, and the state trooper was standing by the window of the other truck. And this defendant, Leo Erlenbaugh, in operating his truck, allegedly operated too close to where the trooper was standing and endangered his safety. And the trooper pursued him and stopped him and gave him a traffic ticket for reckless operation. And the case proceeded to trial in the Wadsworth Municipal Court, and he was found guilty. And his attorney appealed that conviction to the Court of Appeals, argued that the evidence was insufficient, and also argued, I believe, that some evidence that Mr. Erlenbaugh had wanted to introduce should have been permitted in evidence.
Do you remember who the attorneys were?
Ellis Brannon was his firm in Sharon Township.
Sharon Township.
Yeah, that firm. There were 3 different attorneys, I think, involved in the case from that firm.
They were the attorney for the defendant.
For the defendant,
who was
yes.
Mr. Erlenbaugh.
Yes. And it was appealed to the Court of Appeals. And in the Court of Appeals, there was a 3-way split of the 3 judges. There was a visiting judge, Hostetler was his name, from Geauga County. And one of the judges thought the conviction should be affirmed.
Affirm means that they should have maintained it or hold it up or whatever.
Yes,
Okay.
yes. The other 2, however, voted to reverse the conviction. And Judge Hostetler wrote an opinion in which he said that the new Ohio reckless operation law was unconstitutional. Well, that argument hadn't really even been made by the defendant, but he felt the law was unconstitutional because he thought it was too vague. And what the law prohibited was for somebody to operate a motor vehicle in willful or wanton disregard of the safety of persons or property. And he felt the words willful or wanton disregard were too vague. So he thought the law was unconstitutional. And the 3rd judge didn't think the evidence was sufficient to sustain the conviction, so he agreed in reversing the conviction, but not necessarily in the opinion that the judge from Geauga County wrote, who was here on special assignment. So I appealed the case to the Supreme Court of Ohio and did quite a bit of research on the issue and found that there were laws in other states that were written just about identical to the Ohio law, which had been upheld as constitutional. So the Ohio Supreme Court, in a unanimous opinion, upheld the constitutionality of the reckless operation law as it was written. The case was remanded back to the Court of Appeals, and a little bit different panel of judges heard it the 2nd time on remand, and then held 2-1 that the conviction should be affirmed. So the conviction was ultimately affirmed on that case.
You, as an attorney, and I'm going to get myself into deep trouble on this, cannot put your personal feelings into a case. Is that correct?
That's true.
But tell us what your personal feelings are when you win a case in front of the Supreme Court of Ohio.
Well, I was very pleased to win that case, and of course I felt very strongly that the ruling of the Supreme Court was correct, and I had several cases from other states that were consistent with that. And it was kind of a strange thing that had happened in the Court of Appeals, because the opinion in the Court of Appeals that the statute was unconstitutional was an issue that the defendant had not even raised. It hadn't even been argued in that court, but the judge who wrote the opinion felt that way about it, and that's what he wrote in the opinion, but the Supreme Court reversed him.
You said that there were 2 of those such cases. What's the other one like?
Well, the other case was a civil case. It was a zoning case, and it was the case of Ridgely versus Board of Zoning Appeals.
And Ridgely, spell it please.
Ridgley.
Ridgely. Mm-hmm.
And Mr. Ridgely was the owner of a gasoline service station on High Street near the intersection with the interstate highway. And
remember his first name, Mr. Ridgely's first name?
I'm not sure about that.
Okay.
And it was in a zoning district, which at that time it was a different zoning district than it is now. It was called a highway interchange zoning district. And the uses that were permitted or conditionally permitted in that district were very, very limited, and they were designed specifically to accommodate the needs of people who were traveling on the interstate highway. And the ordinance was very specific. It permitted gasoline service stations, but it expressly prohibited the sale of convenience goods. Well, Mr. Ridgely obtained a state liquor license to sell beer at that location. And it was the position of the city that that was a violation of the ordinance, not just because it was beer, but because it was a convenience good, which the way the ordinance was written then, it's a different ordinance now, but the way the ordinance was written then, it was not permitted in that zoning district. So he was given a notice to not use the premises in that kind of way, And he appealed that ruling from the zoning inspector to the Board of Zoning Appeals. That's why the case is called Ridgely versus Board of Zoning Appeals. And the Board of Zoning Appeals ruled against him and held that he could not sell the beer there. He appealed that to the Court of Common Pleas, and from there to the Court of Appeals, and ultimately to the Supreme Court of Ohio. And the issue was basically whether the state liquor licensing system had preempted the local zoning laws so that the city could not enforce its zoning ordinance because he had the state liquor license. And that case resulted in a split decision in the Supreme Court. There's 7 judges, and 4 of them upheld the application of the ordinance, 3 dissented. So the ordinance was upheld that it could be applied to prohibit the sale of beer as well as other convenience goods, even though he had a state liquor license.
Now, when you go to the Supreme Court of Ohio, this is not the regular type of court with juries and so forth. You are all by yourself looking at 7 jurors. Is that correct?
7 judges. Justices.
And how do you do that? Do you just get up there and talk forever, or what?
Well, the time to talk is very strictly limited there. The way it works at that level, they're not taking any additional evidence. They're just deciding the case entirely on the evidence that was introduced at the trial court level. So you go through really 3 stages in the Supreme Court. First of all, they do not automatically take all cases. So they screen cases, whether the case even involves issues that are of a nature that they will take. And so we file, first of all, a memorandum. The appellant files a memorandum in support of jurisdiction, a document trying to convince the Supreme Court to hear the case, and then the other side has an opportunity to present a memorandum in opposition to that. If the court does, in fact, decide to hear the case and grants what's called a writ of certiorari to hear the case, then the 2 sides file briefs with the court, written arguments supporting their position. And then after those are all filed, the matter is scheduled for an oral argument. And on this case and on typical cases, they will only allow 30 minutes for oral argument, 15 minutes per side. On death penalty cases and certain other kinds of cases, they allow more time than that. But on this type of case, it's strictly limited to 30 minutes. And all of the cases for a particular morning are set for the same time. And when I went down there, I didn't know what order my case would be in. So the attorneys for the several cases that are set that morning come in, and they let you know what order you're going to be heard in. And then each side has so many minutes to speak, and the podium there is equipped with colored lights which indicate when you can talk and when your time is up, when you have to stop talking. And the judges can ask questions. 15 minutes per side. And the justices can ask questions. So you can't really completely prepare exactly how you're going to use your time, because you may have 15 minutes planned, but they may ask so many questions that you may not be able to say everything you want to say.
Yeah, there has to be. Now, getting back to Wadsworth, what are some of the, well, maybe there's some humorous ones. What are some of the humorous ones?
Well, we've had a lot of cases, I guess, that involved humor over the years, both in terms of what happened in court and some of the factual background of the cases. I think probably one of the most humorous incidents we had was a kind of a mix-up in words years ago that involved a defendant who had been arrested in one of the bars for assault and disorderly conduct and resisting arrest. And he was in police custody down in the basement of the old city hall. And I was called in the night from home to write up the criminal charges against him, which I did up on the floor above where he was by the dispatcher. And as I was writing up these charges, as is often the case, this man who was quite intoxicated, he wanted to file charges against other people, and I suppose probably wanted to file charges against the police and other people involved in the bar. So he tells the officer who's downstairs with him that he wants to see the prosecutor about filing charges. And the police officer there gets on the intercom and talks to the officer upstairs where I am and says, tell the prosecutor this man wants to talk to him about filing charges. So I say to the officer upstairs, well, I'm not going to talk to him now. I might talk to him later when he's sober, but I'm not going to talk to him when he's drunk. So the officer upstairs gets on the intercom and says to the officer downstairs, tell him the prosecutor will talk to him when he's sober. And upon hearing this, the man says, I don't care if the prosecutor is drunk, I want to talk to him anyway. So that was...
and here's a teetotaler. I mean, you don't drink at all.
No, but he got a little mixed up about who was intoxicated.
You got his direct objects there
Of
taken
course,
care of.
like many intoxicated people, I suppose he had no perception that he was intoxicated. Another case I remember, which was out of a drunk driving case, which was, I think, kind of humorous in a way, or maybe kind of smart on the part of the defendant, was that one of the questions that the police will ask a defendant on the alcohol influence report many times is the question, are you under the influence of alcohol now? Well, many defendants will say yes, they're under the influence of alcohol now, or they will, some of them will deny it, or they'll have a variety of answers to that. But one time a defendant was asked that question, are you under the influence of alcohol now? And the defendant's answer was, if you don't know the answer to that, why did you arrest me?
Good point. That's a good point. A very dear friend of mine went to the doctor one time, and the doctor said, what seem to be your symptoms? And he said, if you don't know what my symptoms are, I'm not going to come to you anymore. What about some of I don't mean to, that's the wrong word probably, but the seedy kinds of things that happen. I know that you've arrested, or rather they've arrested many of the prostitutes out at the truck stop, yes, and bring them. Tell us some of those stories.
Well, one of the things that is really amazing to a person as you watch the court cases go through the municipal court is how many different, what I would call subcultures exist within close proximity to each other in the court's territory. And there are just people out there who live lifestyles that people would be amazed that those lifestyles exist right in our community or within our court territory. And of course the interstate highway brings a great variety of people and lifestyles into our court, and the truck stops bring people from all over the country. And one of the problems historically at the truck stops has been prostitution. And
in other words, the girls go out there and solicit truck drivers.
Yes.
Because they are by themselves most of the time.
Yeah.
And fairly lonely, and whatever.
They will come from the cities, and people who manage them will come with them, and they will engage in their occupation at the truck stops. And the truck stops, of course, have tried to prevent that as much as possible, and they have done that by posting the truck parking lots with signs which prohibit people from being there unless they are truck drivers or members of truck crews, people with legitimate purposes being there. And I don't think it's as much of a problem now as it was a number of years ago, but a number of years ago it was quite a big problem. And of course the prostitutes would use CB radios to advertise and communicate with truck drivers. And when they would be arrested, oftentimes they would be people who it was difficult to identify. They would not have any identification, or they would have maybe identification under several different names. Sometimes they would go by various aliases.
Can you remember any of those aliases, which might be somewhat humorous?
I can remember one went by the name, I believe, White Rabbit. I believe
Rabbit.
that name would be used on on the CB radio. I know there was at least one instance in which a young woman was arrested there and prosecuted and went clear through the criminal justice process, and then it was later determined that she was actually a juvenile and should not have been in the adult court, should have been in the juvenile
Wow.
court, but she had misrepresented her name and misrepresented her age, and so she went through the system as an adult.
Now, when they were arrested for prostitution, do they have to be caught in the act, or can they just be walking around the truck stop? How do they do that?
Well, very few of them were actually charged with prostitution because that was very, very hard to prove, but many times they were prosecuted for trespass, for being in the area where they were not supposed to be, in violation of the signs that were posted. And there were some where they could be prosecuted for prostitution. There certainly were cases also where factually the facts indicated that's what was going on, but the witnesses were out-of-state truck drivers that you couldn't get back to testify in court. That's one of the problems with things that are related to the truck stops and trucks, and this is true even of motor vehicle accidents involving trucks. If you have a truck driver who's from California or even Pennsylvania, they don't want to come back and testify, and if they're out of state, it's very difficult to enforce that.
We're going to get back to some of these stories of the prosecutors, but let's take a little break from that and tell us about the prosecutor's office when you first started. What were you expected to do? What kind of help did you have? Who were some of the first people with whom you worked and all that type of thing?
Well, when I first started, the City of Wadsworth had a solicitor and an assistant solicitor, and both were very part-time positions.
And solicitor is an Old English word for what?
Well, in England, the legal profession is divided into two branches, barristers and solicitors. And barristers are trial attorneys who try cases in the higher courts. They wear wigs and wear gowns. Yeah, to this day. And solicitors do office work, more advising people and preparing documents. They also try cases in the lower courts in England.
And don't wear wigs?
No, they don't wear wigs. They wear, sometimes they wear robes or gowns, they would call them, in the lower courts, but they never wear wigs.
What is the significance of the wigs? Is it just a tradition?
It's just a tradition, and it's a way, I guess, of making the barristers stand out so everybody will know who they are and what they are. And of course, the judges wear wigs too in England. They wear a different kind of a wig than the barrister wears, though.
Well, you surely would stand out if you had one of those white wigs on. We wouldn't want you to do that. So you stay with the lower courts.
Yeah.
Who were some of the people with whom you worked at the beginning, and how did that all evolve?
Well, when I started, I was assistant city solicitor, and I handled the criminal cases.
And who was the solicitor?
Joe Foreman.
Joe Foreman, another very good friend, and certainly he was on our program once before.
And I started as his assistant October 2nd, 1973, and I was his assistant for 3 months, and he resigned as city solicitor and was replaced by John Goulden.
John Goulden, a big, tall man.
Yes.
Mm-hmm.
And
his wife was involved somewhere with special education, and
she interpreted for the deaf.
For the deaf, yes, right. Mm-hmm.
And he was city solicitor for 1 year, for 1974, and I was his assistant throughout that year. And then he resigned as solicitor, and then Charles Johnston was solicitor then for
Charles Johnston is still in our city, and he was also interviewed here. Where is Goulden now?
He is in Columbus, Ohio, and
John Goulden.
Yes, he is attorney for the Bureau of Motor Vehicles in the state of Ohio, and I have had occasion, even within the last couple of years, to talk with him on the phone about some issues involving driver license suspensions.
Now, John's wife one time with sign language, sang the song, of course, in quotation marks, of Leroy Brown, bad Leroy Brown, whatever, I don't know the words to it. But she did that for a large gathering, and it was just absolutely tremendous. I just will never forget that. And who were some of the people, other people with whom you worked within your office?
Well, at that time, I really didn't have any other staff in my office.
You did your own typing, you did your own everything.
Well, if I had typing to be done, the mayor's secretary would do that for me. That was Barbara Fish.
Barb Fish at that time, who then ran for mayor against Charles Daniels, Dr. Charles Daniels, and most people called him Bob, and his wife called him Dan, D-A-N, for Daniels. And after she had worked for, she was secretary for J.D. Henson, Mayor J.D. Henson, was she not? And then she would do your typing. But was it as effective as you needed to have it done? I mean, not that she wouldn't do it, but I mean, she had other things to do too. I mean, she would have tons of things to do.
Well, she was very good and very conscientious.
Oh,
she did a very good job for me.
A slave worker. She was a tremendous worker.
I will say at that time we didn't have nearly as much typing to do as we would have now. Very, very little, because cases were handled very, very differently then. The volume of cases, of course, was much smaller, and in those cases, in those days, far fewer cases were contested and went to trial. There was far less in the way of motions, far less in the way of discovery. Now, discovery is really a big burden on the law director's office.
Tell us what discovery is.
Well, discovery is the right that a defendant has to information about the case. And on just about every case now, the defendant's attorney will file a request for discovery. And that means the prosecutor's office has got to prepare for him information about the case, about the people who are going to be witnesses for the prosecution, their names and addresses. We've got to check out if they have any criminal record. We've got to check out if the defendant has any criminal record and reveal that to defense counsel. We've got to make defense counsel aware of any statements that the defendant has made, of any tests like a breath test or a blood test that we intend to use in evidence. And over the judicial system generally, over the state of Ohio and over the country generally, a lot of times there are a lot of issues and controversy about discovery, whether something was provided that should have been provided. And so we have to be very careful and very meticulous to be sure that we provide everything we need to provide. And that, of course, involves attorney time, but it also involves a lot of secretarial or paralegal time in preparing that information. So that is something that has changed over the years. Also, there's more now required in terms of preparing briefs to file with the court and memorandums, legal research.
I heard you talk about paralegals. You have a paralegal now?
Yes, I have actually 2 people in my office who function as paralegals.
Now, you didn't start with 2. You didn't start with 1. Who was the first one, and how did that all evolve?
Well, in the beginning, as I say, I just relied on the mayor's secretary when Barbara Fish was there in the 1970s. And then in the early 1980s, Carol Lang was the mayor's secretary. And
Carol Lang was wife of Gil Lang, and Gil Lang is
his daughter.
Yeah,
Carol Lang was his daughter.
That's right. And Gil Lang is now deceased, is he not? Yes.
And Carol Lang is now Carol Hartman. She's married and lives here in town. And in 1984 is when I first got my own separate secretary.
In other words, from 1970 what? 73 to 84, 11 years without a secretary.
Yes, without full-time.
Without a full-time secretary, borrowing somebody else's secretary. And who was that person?
Linda Gehring.
Linda Gehring, who is now Linda Gehring Bowers.
Yes.
Linda Bowers. And she served as your secretary for how many years?
Well, she served as secretary, and then later the title was changed from secretary to paralegal to reflect the change in the scope of the duties. She was there in those two positions from 1984 to 1996.
Right. Now, she advanced herself personally by studying for the paralegal, and as I remember, she had an extraordinary experience at Harvard University. Is that correct?
Yes, she did.
What was that experience at Harvard that you supported her to attend?
Well, actually, she and I both went to Harvard at different times. In the summer of 1987, I believe it was, they have a continuing legal education program, a summer school at Harvard for attorneys, and I went there for a week, lived in one of the dormitories at the Harvard Law School. It has kind of its own little sub-campus there with its own dormitories, and I took a course in land use law, zoning and other issues related to land use. And while I was involved in that, I got a lot of literature about the various programs they had. And they also had a course that was available to non-lawyers as well as lawyers on negotiating, on the scale of negotiation. And Linda became very, very interested in that. And so the next summer she went and took that course at Harvard Law School, and I know she enjoyed that a lot and really did get a lot out of it. She was, I think, had a lot of negotiating skill before she went to the course, and I think that really helped her out.
This is very valuable to the city for that reason.
Mm-hmm.
Then who else came on to your staff?
Well, Brenda Fisher started in 1988. And I would say during the 1980s there was a tremendous increase in the workload in my office, partly because of the great increase of focus on DWI cases.
And why was that?
Well, in the early years, DWI cases were generally settled on negotiated pleas rather than going to trial. And in the 1980s, the law became much more stricter. The penalties became greater. Public attitudes changed, and negotiated pleas were no longer part of the system on DWIs.
And as I remember, Judge Kimbler was very adamant about DUIs and came down hard on them.
Yes, and this meant there were far more trials, there were more jury trials, there was more extensive discovery, there was more motions filed in cases, there were more appeals, and so it is what needed to be done, and I'm entirely in agreement with what was done, and part of it was it did involve more staff being needed for the law department.
Yeah. Now, talking about Judge Kimbler, we left Judge Ott, and then after Judge Ott, who was the next judge? We want to get the succession of judges.
Judge Ott resigned in the spring of 1974, and Richard Dickey was appointed by the governor, by Governor Gilligan, to take his place. And he served the balance of 1974, and then he was defeated in the election in 1974 by C. David Hensel, who was elected judge of the county court, which at that time continued to be a part-time position. And then when the municipal court was created, there was an election for that position in 1976, and C. David Hensel was elected to the first term as municipal court judge, and then he was re-elected to another term as municipal court judge, and he then died in office the very last day of 1985.
1985, and then immediately following that, or not immediately following, but there was an interim judge, and then a judge was seated by appointment, and that was Judge James Kimbler.
Yes.
Correct? And then he was re-elected, what, 2 or 3 more times?
He was appointed by Governor Celeste in the very first part of 1986, and then he was elected in a 3-way election in 1987.
Who were the 3 opponents?
Joe Foreman and Philip Croyle were the other 2 candidates.
And Judge Kimbler then became the judge again.
Yes.
And then he was uncontested for the next time, is that
Yes.
correct? And then he was elected to the Judge of Common Pleas, is
Yes.
that correct, in Medina? And at that point, there was an appointment made by the then sitting governor, who was Voinovich.
George Voinovich.
And he appointed the
Stephen
president,
McIlvaine.
Stephen McIlvaine, who is at this, as we speak, the judge of the municipal court in
Yeah.
Wadsworth. Then he has to run at the end of this year, does he not?
Yes.
Because it was an appointment and he was filling the unexpired term of Judge Kimbler. We just want to get that progression of people. Let's get back to some of the extraordinary cases that you've had. And we have hit some of the humorous ones. We've hit some of the, well, for the want of a better word, the seedy ones. How about some of the tear-jerking ones, the ones that have really hurt you?
Oh, I think probably the most difficult type of case we have are vehicular homicide cases.
And they're very difficult.
And those are very, very difficult cases.
And do you have any recollections of some of the proceedings of these kinds of cases?
Yes, I remember a number of them. I remember we had one many years ago, fatal automobile accident in which the victim was the sister of the defendant. And that was a very...
Now say that again. The victim. No, say that again.
The victim was the sister of the defendant. She was a passenger in his car and was killed.
Oh, okay, all right. The sister was the victim was the sister of the defendant.
Mm-hmm.
Now that was a celebrated case that happened around Easter time, as I remember, did it not?
I don't remember exactly when it happened. There was a group of young people who were part of a church youth group in Barberton, and they had been to...
oh, wait a second. That was one that happened on Silver Creek Road.
Yeah.
Okay, in the...
Actually, I think now that I think about it, I think it was in the fall.
yes,
maybe.
this was in the fall of the year.
Yeah.
Yes, that's correct. I was thinking that it was the one in which Pastor Wolf's daughter was killed. Was that...
That was before my time,
before
and
your
that was not in... I think that was in someplace else.
Tell
That's
us
where
about that case. It went on for years and years.
Well, this case in which the driver's sister was killed was a very, very tragic accident at the railroad tracks on Silver Creek Road.
Not at the tracks itself, but over the tracks.
Yeah.
It hit a piece of earth-moving equipment which was parked in the field, but the railroad tracks contributed. Tell us how that happened.
Well, they were doing work on the tracks there, and I don't remember all of the details as well as I knew them certainly at the time, but the driver did lose control of the vehicle, and there were several people that were very seriously injured, and the sister of the driver, who was one of the passengers, ultimately died, and that was a very difficult case. And then, of course, he was acquitted by a jury. It's a very hard type of case to get a conviction on, partly because the way the law is worded on that type of case.
As well.
And there was also civil litigation out of that, in which the city was sued, and the railroad was sued, and the construction company was sued that were involved in
Remember
the project.
The name of the construction company?
Kokosing Construction.
K-O-K-O-S-I-N-G from...
Mount Vernon area.
No, yes, Mount Vernon area, but it's... I can't think of the name of the little city down there, but they were doing I thought they were doing work on the sewers,
Yeah.
and the park there beyond the railroad track. How about going to something that's not so terribly tear-jerking, and some of the cases, for instance, there was the case of the Amish person who could not come to Wadsworth, and you had to prosecute him. The case of the person who caused City Hall to be built because we had to transport him upstairs and there was no elevator, things like that. How about spelling out these next couple of minutes that we have, and we always run out of time, but tell us about some of those kinds of things.
Okay, the Amish case was the case of State versus Schwartzentruber, and it involved a young Amish man out in Homer Township. And
Homer Township was approximately how many miles from here?
About 25 miles.
25 miles.
It's the far western township in our court territory, and there are many, many Amish people in Homer Township. And he was hunting deer, but not wearing the hunter orange color, which was required by the wildlife regulations. And he was cited by the state wildlife officer for that. And the issue in the case was whether it was a violation of his rights under the First Amendment to freely practice his religion to enforce this law requiring him to wear the hunter orange if he was going to hunt deer. And of course, wearing the hunter orange was contrary to the rules of that particular Amish group. They're called Schwartzentruber Amish. They're the most conservative group of Amish.
And the man's name was Schwartzentruber also?
His name was also Schwartzentruber. They're not all named Schwartzentruber, but he was. And I went out several times and talked to the senior Amish bishop about it, and they would permit him to wear red, but not orange. So the issue in that case was an issue of the constitutionality of the state rule, and ultimately the constitutionality of the rule was upheld. The court, under the way the law was at that time, did not feel that it placed an impermissible burden on his religion. Now, this is an area where the law has changed between then and now. There's always so much change in the law. At that time, in order to defend the law, it had to be shown that the state had what was called a compelling state interest for having that requirement. But since then, the U.S. Supreme Court has decided another case that has relaxed that standard. So now it would not be necessary to show a, quote, compelling state interest in order to make that law enforceable.
Now, as I remember, Judge Kimbler heard that case, is that correct?
Yes.
And since there was I guess it would be a difficult task for this man to come into Wadsworth 25 miles on a horse and buggy, you held court out there.
Yeah, we held an arraignment out in the township building in Homer Township. The Schwartzentruber Amish will ride in cars, and in fact they have a little bus service that runs through there. They will ride in cars under certain circumstances where they feel it's absolutely necessary, but the bishop didn't feel that it was necessary for him to ride in a vehicle to come to the court, so he would have come with his horse and wagon to Wadsworth rather than ride in a vehicle, and he would have done that. But the court concluded that that was not very safe, so for safety reasons we'd rather go out and have the court out there rather than have
My guess is that it was a difficult one for you to handle, is that right?
It had some difficulty to it.
And what about the elevator one? Tell us about that one. We're almost out of time.
Well, years ago we had a man charged with domestic violence who appeared in court in a wheelchair and claimed he couldn't get up to the court, and as a result of that he was arrested for failure to appear in the court. The court didn't really believe that he could not get up to the court, and
especially had he not been in some kind of a physical altercation with the other person?
Yeah, he had been involved in alleged violent offenses, and as a result of him claiming he was not able to get to the court because of the stairs, he filed a lawsuit against the city, and it became quite an expensive undertaking, and it was finally settled. But there was always this lingering issue about the accessibility of the court and to some extent the other city offices. So fortunately we were able to resolve all those issues by having a building now that is very, very accessible to everybody.
Norman, once again we want to thank you for sharing these things with us. You bring a tremendous amount of our history through the courts because you probably have been the longest serving prosecutor / law director in the City of Wadsworth for its entire 185-year history. So thank you again, and we might have you come back again to finish out some of these kinds of things because they're extremely interesting and certainly add to the history of Wadsworth. Thanks, Norman. We appreciate it.
Thank you.